Uh, okay, good evening, and welcome to this online discussion organised by the Social Work Action Network here in the UK. My name's Andy Brammer, and I'm chairing this evening's discussion, and I'll introduce the speakers in a minute. Tonight's discussion is titled "Fighting for Social Justice: What's Happening to Human Rights During COVID-19," and this is one in a series of discussions that have been taking place both in the UK and internationally, alongside the International Federation of Social Workers. We had our first online discussion it's about 6 or 8 weeks ago now with the IFSW, and I think we recorded somewhere in the region of about 20,000 people internationally watched the live streams and watched the recordings of that discussion. And since then, there have been subsequent international discussions, but we've also been through the IFSW and through Social Work Action Network International, been encouraging discussions like this to take place nationally, and some very successful meetings have taken place both in the UK and in other countries. Just in the last week, there's been a very successful forum of social workers in South Africa, and in Greece just a week ago, 15,000 social workers tuned into a discussion like this. So the format for the meeting this evening is that we have three speakers. We have Derek Boothby, and Derek is a social worker, approved mental health professional, best interest assessor, and teaches in some of the universities in Yorkshire around these issues, and is also the regional chair for best interest assessors in Yorkshire. Derek's going to be our first speaker. We also have Carolyne Willow. Carolyne Willow is also a social worker. She's part of an organisation called Article 39, and she's a children's rights campaigner. Carolyne is going to speak second. And our final speaker will be Luke Clements. Luke was previously a solicitor. He's currently a professor of law at the University of Leeds and specialises in disability rights legislation, particularly relating to children, and advised government in relation to things like the Care Act. Each speaker is going to speak for about 10 minutes, after which we will be taking questions. Well, the way that the questions will work is that through the live feed, if you put your questions and comments onto the live feed, or you message them in, you can either direct them to the whole panel, or you can direct them to individuals, and we'll select them, and hopefully there'll be time for a couple of rounds of questions. So without further ado, I'm going to invite Derek into speak. I'm just looking on my screen at the moment, and Derek had some problems with his connectivity earlier, so I don't know if I get a thumbs up from Carolyne or Luke. If Carolyne, if you could start, and we'll try and find Derek in the meantime. So if we can go over to Carolyne. Thanks for that, Carolyne.
Okay, thanks, Derek. I'm just keep looking in the corner of my screen because my charity has threatened legal action against the Department for Education, and it's their deadline today to respond to the letter before claim, so that may happen whilst we're live. So I'm going to talk about the Adoption and Children Coronavirus Amendment Regulations 2020, otherwise known as Statutory Instrument 445, and how that relates to children's human rights. And my contribution is in 3 parts. So firstly, I want to start by just recapping what we mean by children's human rights. Then I want to quickly whiz through what Statutory Instrument 445 is all about, and then just to end with what are the risks to children's human rights from Statutory Instrument 445. So human rights, as we know, are at the heart. You said social, we have to admit to promote and respect the human rights of people being children and adults. I've just got something saying my internet connection is unstable. Can you'll do something if, yeah, okay. And so promoting and respecting human rights demands action. And human rights clearly emanate from ideas and ideals, thoughts and feelings and values and attitudes, as well as connected that feelings are central and the fuel for human rights. But human rights also have a material existence. They are tangible and practical in our lives and also in our laws. And so for children's human rights, there's 2 aspects to take into account. One is at the international level, which is the UN Convention on the Rights of the Child, and the other is the Human Rights Act. The UN Convention on the Rights of the Child, Nelson Mandela referred to it as that luminous living document that enshrines the rights of every child without exception to a life of dignity and self-fulfillment. It's a very comprehensive human rights treaty. It combines economic, social and cultural rights with and political rights, substantive rights. When the convention was first adopted by the UN in 1989, the Committee on the Rights of the Child, which is the UN monitoring body, selected 4 aspects of the treaty as overarching general principles. And these are Articles 2, 3, 6 and 12. Article 2 entitles all children to all of the rights in the treaty without any form of discrimination. Article 3 is the right of children to have their best interests treated as a primary consideration in all actions concerning them. That applies to individual children as well as children as a group, as a constituency. Article 6 is the child's right to maximum survival and development. So that goes way beyond the right to life that we're accustomed to in ordinary other human rights treaties. And Article 12, which is probably the best known of all the articles in the Convention on the Rights of the Child, gives children the right to express their views freely and to have these views given due weight in all matters affecting them. So the Convention on the Rights of the Child isn't part of our domestic law, parts of it, but it hasn't been incorporated like the European Convention on Human Rights has, which, as we know, is through the Human Rights Act 1998. And the most pertinent aspect of the Human Rights Act, for what I'm going to go on and talk about, is Article 8, which is every child's, as well as adults, right to physical and psychological integrity, the right to family relationships, the right to participation in decision making and prevention of abuse, as well as protection from abuse. That's Article 8 as it's been interpreted both by Strasbourg as well as our domestic courts. So what do human rights do, and why are they important to children's social work? Top of the list is that they assert the human dignity and worth of each person, no matter what their age, their background, the circumstances of their lives. And by the very nature, this is open, this is inclusive, and this is affirming. And the reverse of that is stigma, is pathologizing individuals and communities and groups, and excluding people. It establishes the minimum required standards for a fulfilling life, whether that's a child of 4 or an adult of 40 or 90. These are the bottom lines that the international community has agreed that we all need to have a fulfilling life. They provide a vehicle through which people as individuals and groups, including family groups, can make claims for what they're entitled to, and it gives a mechanism for challenging breaches. And finally, just on this little slot as to the importance of human rights, in my mind, it redistributes power from the state and the professional to people who are in need and currently receiving social work. And it provides a rule-based system, which at least in theory, everybody can understand and access and make use of. So what is Statutory Instrument 445? It's a document that overnight has made substantial changes to children's social care law. It amends 10 different sets of regulations, and I'm just going to give you a quick rundown as to what the regulations are. Residential Family Centres Regulations 2002, Adoption Agencies Regulations 2005, Children Private Arrangements for Fostering Regulations 2005, the Children Act Representations including Complaints Regulations 2006, Education and Inspection Regulations 2007, Care Planning, Placement and Case Review Regulations 2010, Fostering Services Regulations 2011, Children Act Joint Area Reviews Regulations 2015, Children's Homes Regulations 2015, and the Inspection Regulations 2015. The reason I wanted to use up time to list all those regulations, effectively 100 changes that have been made in total to those regulations, taken away or diluting 65 legal protections for children in care and children who could come into care. We're expected to believe that all those so from the 23rd of March, when we all went into lockdown, to the 20th Parliament, and it came into force the next day. All of that work, we're expected to believe, took place in that period. I've never myself come across, and I've worked closely with the law, primary legislation and secondary legislation for 20 years, and I've never seen a statutory instrument that changes so many aspects of law linked to different primary legislation. But that raises an eyebrow rather than the blood pressure. That's curious, interesting, unusual. It's not the whole point of what's happened here. What is intolerable about Statutory Instrument 445 is that overnight it made changes to children's legal protections that had bit by bit, incrementally, since the 1940s onwards, been put in place to protect children. I've got the whole list here, but I'm nervous about running over time, so I'll skip that for the minute. Instruments are laid, and Parliament is 21 days to scrutinise and debate and check what the proposed changes to law are. So not only were all the changes to the 10 different sets of regulations combined together into one document, Parliament was given no time. The changes came into force overnight. There was no parliamentary scrutiny, and also there was no public consultation. The Department for Education claimed in their explanatory memorandum that was published with the statutory instrument that it was demand from the social care sector, children's social care sector, that precipitated this statutory instrument, that they were in a state of urgency and they had to be brought in possible for them to find out what happened to children's services until the lockdown, and then they had to bring them immediately into force. The same document named a select group of organisations which have all, one by one, publicly denied that they were consulted on the detail, or indeed that they asked for the legal changes. So let's just explore for a minute the emergency narrative, the urgency of removing 65 legal safeguards that had been bit by bit put into law for children in care and for children who could come in to care. Even in an emergency, in a democracy, a government must provide justification and rationale for removing legal protections, not least from its most vulnerable citizens, children who are in the care of the state, for whom they are a corporate parent. Apart from name dropping a few organisations and claiming that they asked for the changes as a matter of urgency, the government hasn't done that. It's not provided the rationale or the justification for each of those changes. And its failure to explain each of those changes, how they're linked to COVID-19, that leads me and many others to suspect that what's happening here is deregulation under the cover of COVID-19 in the interests of government rather than the interests of children. I've worked in policy, advocacy and campaigning for many years, and this agenda to deregulate children's social care goes back to the red tape challenge in 2011, when children's services were bundled together with a Cabinet Office project to remove regulatory burdens. So children in care were situated next to retail, to manufacturing, to health and safety, to employment law. No special status was given to children in care and child protection for a category of people to be protected from this deregulation agenda. So they were there next to questions about how can we make business work easier, how can we support business owners, how can we support employers, how can we free up red tape and regulation for them. Children were in the same headspace, vulnerable children were in the same headspace for that project. However, that process, and they did have what they called a star chamber, where civil servants had to go and justify the regulations and why it was needed. And in 2011, the civil servants clearly did a great job, because no child protection or children in care regulations were removed through that red tape challenge. The next serious attempt was in 2016, when, without any public consultation, without a green paper or a white paper, a bill was introduced into Parliament which proposed to allow local authorities to opt out of any number of their children's social care duties for up to a period of 6 years as a trial, for then removing those particular duties altogether. That was knocked out in the House of Lords. The government reinstated the clauses, but they could not get the support of the social workers, of children's lawyers, of charities, and the wider children's social care sector. So they had to abandon their attempt to dismantle the legislative framework for children's social care then. The reason that is really relevant is because many of the headline changes that have happened through Statutory Instrument 445 were the target, they were the target legal protections that ministers in Parliament and outside of Parliament said that's why they needed those exemption clauses to be able to test their removal.
Carolyne, can I just ask you to sum up your introduction, please?
Yeah,
Thank you.
yeah. So the Children's Minister earlier this week admitted that the department knows of no local authority that is currently applying the changes. And yesterday, the Association of Directors of Children's Services was quoted as saying that they are working very hard to meet their statutory duties. I've no doubt that local authorities are working hard to meet their statutory responsibilities. But the point of this is that on the 24th of April, the statutory duties changed. So when directors of children's services talk about meeting their statutory duties, whether they understand it or not, they are referring to the law as it was changed overnight on the 24th of April. And because the statutory responsibilities have been radically changed, from a children's human rights perspective, we are having to defend what was already in place the day before. And so in closing, I'd want to stress that we are not the radicals here. We are the moderates. We are defending the status quo, that all those legal protections that existed up to the 23rd of April, they all have statutory guidance from government, each and every one of them explaining why they are fundamentally important for children. And it's those who have achieved the radical deregulation that are the extremists. I'll stop there.
Okay, thank you very much for that, Carolyne. It's been a very comprehensive overview in a very short period of time of the situation in terms of human rights and children. There's already quite a few questions come in, but we'll wait to the discussion part to raise those. I think from the public's point of view, that the kind of big concern at the moment regarding children is the return to school issues and the risks associated with that, and the feeling that you know what is going on to put the most vulnerable in the firing line in that way. And I think what you've summed up is that behind that is even more vulnerable children who are being exposed to quite a significant attack on their human rights. But we'll be able to pick that up a bit more in the discussion. I'm now going to bring in Derek. Derek's back with us now, so I'm going to ask Derek to come in and to do his introduction.
Hi everybody. Sorry about disappearing, but my bandwidth is a little bit dodgy, so I apologise in advance. My name's Derek Boothby. I'm the Mental Capacity Act lead for Wakefield Council, but this evening I'm speaking on my own behalf, so nothing to do with my employer. I also teach on AMP and BIA qualifying courses at various local universities, and I am a practicing AMP and BIA myself. On top of that, I chair the Yorkshire and Humber Regional Mental Capacity Act Forum and attend national meetings in various parts of the country where we talk about all things Mental Capacity Act. I think the challenges for adult services are, well, many and varied at the moment. When we talk about training social workers and we talk about human rights, and that respect for and adherence to human rights is one of the fundamentals that we as social workers will always be putting forward. In adult world, we talk a lot about Article 5, the right to liberty and security. We also talk a lot about Article 8, the right to private and family life. And that Article 5 in particular, when we're talking about if we need to deprive people of their liberty, and we're talking about a procedure prescribed by law. So when we're talking about the job of an AMP, an approved mental health professional, or we're talking about the job of a BIA, a best interest assessor, we are talking ultimately about depriving people of their liberty in quite difficult circumstances. So up until recently, Article 5 and Article 8 were our main watchwords, and that ensures that anything that we do is legally compliant and compliant with human rights legislation. However, COVID has thrown a massive spanner in the works insofar as we now have to think more about Article 2, about the right to life, and about the fact that we may be detaining people who may end up in hospital or may end up in a care home where they may be vulnerable to the Covid-19 virus. And is that right? Is upholding people's right to liberty and security or whatever, is that going to override the right to life? And I don't think it is. So we're facing lots and lots of challenges as an adult profession. Another example is that currently most local authorities that I know of are working very, very closely with our health colleagues. And the idea being that we keep hospitals clear of patients so that we've got plenty of room for people who may develop COVID-19. I can totally understand that happening. I appreciate why that's necessary. What it means in effect sometimes though is that within a very short space of time, people are moved from hospital, usually elderly people, from hospital, and they're placed in care homes, where we're aware that the testing for COVID is either not being done or it's not very accurate, and they are now the population that are dying in big numbers in care homes. That COVID-19 was seeded into care homes by the introduction of patients from hospital without testing taking place. So as a social worker and as someone who works in that field, I then may have to be in a position where if that person lacks capacity, for example, and needs to be detained in that care home where there are massive risks, then we are having to engage our BIA systems and interfere with that person's Article 5 and Article 8 rights to keep them in a place that's inherently dangerous. So for me, I think there are massive challenges about how we do that safely. Likewise with the Mental Health Act, that we detain people under the Mental Health Act. Now, I know that some psychiatric hospitals have now got COVID wards, so people detained under the Mental Health Act who've developed COVID-19 in specialist wards. But we're still expected to admit people to what are inherently unsafe environments. We did look and did hope that the government would offer some sort of guidance to us to help us to navigate our way through these difficult times. What we've been told very clearly is that there's no easement. There's no easing of the law around the mental capacity, the MCA. There's no easing of the law around the way that we use the Mental Health Act. That those pieces of legislation are still in place and still have got to be adhered to. So I think that what's been happening on the ground is that a lot of local areas are developing pragmatic solutions to a very difficult question without having particularly any reasonable guidance from government or from the Department of Health and Social Care to help us on our way. So we're trying to minimise as much as possible contact, and that's to protect not only us as the worker, but the people that we're working with, our service users. We don't want to be going into a care home, for example, and introducing COVID-19 into a care home where it's not already present. So we are using quite a lot of assessments done virtually by using systems like this, by Zoom or by Skype or WhatsApp or whatever. Although they are not perfect, they are enabling us to maintain legal oversight to make sure that what we do has got a legal basis, and hopefully in the fullness of time, when we're back to normal, that a lot of the assessments that we've done will be repeated when they can actually be done face to face. So for me, there are quite a lot of challenges. I think it's a very difficult situation. I don't want to sound critical. I don't think there's a right or a wrong answer anywhere. I think that we could have been given more guidance centrally by government about how to work this. And I think that the emphasis on keeping the hospitals clear and placing people in care homes has probably been the biggest mistake that I can think of. And I would like to see that rectified if possible. I think that's it for me, Andy.
Okay, thank you, Derek. And again, covers some of the pertinent issues that we're seeing emerging at the moment, particularly in and around the care homes. I mean, we're looking particularly this evening around what's happening in the UK, but as Derek has highlighted just then, we've got people in care homes, which are supposed to be the places where we are protecting the most vulnerable. But at this moment in time, these are places where the most vulnerable are being exposed to the coronavirus and all the effects. And interesting to look at some of the international comparisons with countries like Japan, New Zealand, and elsewhere, how they've dealt with the care home issue and how they have much lower numbers of deaths, and what we're having to face some of the real dilemmas that Derek has highlighted there in terms of how do you keep vulnerable people safe in institutional care, essentially at this moment in time when those institutions are some of the most infected places in the country. So I'm going to bring us on to our final speaker now, who is Luke Clements. I believe Luke is back with us, so I'm going to hand over to Luke.
Can you hear me now?
Yeah.
Yeah, this is great. Sorry, I've just had a 15-minute, 20-minute nightmare trying to sort out this computer and my ineptitude. So thanks everyone for inviting me. Really a great pleasure. I should say this is the first webinar I've ever been on. And I suppose it's going to be fairly obvious from my ineptitude. What I'd like to talk about is to sort of draw back and look at the bigger picture. So yeah, I am still a lawyer. I have taken cases to the European Court of Human Rights. I've taken lots of judicial reviews, but I'm slightly jaundiced about the idea of human rights litigation being a vehicle for change. It's incredibly important in righting individual wrongs. And we've heard of some sort of truly awful developments from Carolyne and Derek. In a way, I want to look at what happens afterwards. What's happened with Statutory Instrument 445 and the emasculation of children's services, the government doing in a crisis what it wanted to do many years ago is just horrific. And what is happening in care homes, I'm particularly worried about the idea that the Care Quality Commission just withdraws from unannounced visits, withdraws from routine visits without really justifying why, when, you know, it's a fundamental provision of the Torture Convention that people in institutions are watched very, very carefully, you know, from Winterbourne to Bournemouth to all the other atrocities. And then just like that, the Care Quality Commission says no. I'm appalled at the way that the Ombudsman have just stopped looking at cases. They've just shut up shop. And I'm appalled at the way that local authorities are pausing that. My concern is that very soon, I think, the Care Quality Commission will start saying, well, we will start visiting again. And I think the government will back down. I'm sure it will back down on the Children's Reforms Section 4, you know, the statutory instrument that Carolyne has spoken about. And I think the Ombudsman will open up their shops again. And I think NHS England will start taking the pause button off. And then we're at risk of the government saying, well, all of these problems that you were worried about have gone away now. We're back to normal. And you should be really pleased. You know, we're not banging your head against a brick wall anymore. So you should all rejoice and clap and do those things because we're back to normal. But of course, normal was appalling before this happened. You know, DOLS is a complete catastrophe. The treatment of children, looked after children, is a national disgrace. CAMS is a national disgrace. And adult care is just dreadful. And I'm worried, I think that clearly it's tempting at times like this to focus on the acute issues of challenging some of these serious individual violations that are happening. And there are plenty of lawyers, and I'm on panels where we're involved in that sort of stuff. But now I think is the time for us to start planning about what is going to happen in the aftermath. That we're not going to put up with the sort of half-baked solutions. And in adult social care today, I don't know if you've seen, but the government has pre-released, quite cynically, a proposal that they will bring back the DIL cap on costs, care costs provision. Now that was something that was trialled almost 8 years ago, 9 years ago. It's a complete disaster. It won't help one disabled person who's getting social care now. It won't put a penny into social care budgets. It won't in any way affect the crippling care charges that individual service users pay. It won't do anything with the fragmented, privatized social care provider system and all its offshoring and debt leverage that is going on there. It won't do anything whatsoever for existing users of social care. But it will, of course, save a few people who don't at the moment get social care from the state having to sell their homes. And that will be a cost that will have to come out of the existing budget. So I think just as in 1941, the government asked Sir William Beveridge to start looking at reform, I think we've really now got to pay a lot of attention to what is going to be acceptable and what's not going to be acceptable when these acute violations go away, and what we're going to be asking for. In social justice, we're sort of interested in the fair distribution of wealth and the fair distribution of opportunities. But we're also interested in the fair distribution of privilege. And I suppose the thing I sort of leave on is that we've heard a great deal about the fact that although we're all vulnerable to this virus, it's affected us all differently, and it's affected us differently because of the socioeconomic disadvantages. Human rights is not just Article 8 and Article 8, not the European Convention, it's also about social justice and socioeconomic human rights. And when we look at socioeconomic human rights, we often tend to look at Black and minority ethnic groups and working class, working manual trades and saying how badly they do. But I think there's going to be a need for us to start focusing not on that group, but on privileged groups, and to ask, what is it that the people living in Richmond or in some of these highly privileged areas have done to deserve the fact that they are not victims of this? What is it the people that have these 10-year more life expectancy than everybody else have done to earn that privilege? And in a way, to ask that question rather than the fairly obvious question is, why are poor people dying in such numbers? Well, it's obvious. But if we turn the light on saying, what is it that people with privilege have done to justify that, we can then start saying, well, I think we could expect you to pay quite a lot more in tax, which is, of course, the only thing that's really going to make a big difference here. So I'll leave you on that. Thank you.
Thanks for that, Luke. I'm unmuted. Yep, yeah, thank you for that, Luke. As you said, you've given us the kind of broader picture that sits behind this in terms of human rights and the Convention on Human Rights. We've got some time now for questions for each of the speakers. So what I'm going to do first of all is to ask questions to speakers individually, and then if there's any kind of collective questions. So the first questions, there's a few questions of a similar nature for Carolyne, which were around the changes that you had described in children's legislation. How did the government justify such a massive set of changes to children's social care legislation? And I suppose linked to that is why? What do they want to get from the deregulation of services? What is the government aim on this, and what do you think the impact of those changes will be on children themselves?
Okay, so just to talk first about what the government's justification is. On the 23rd of April, the day before everything came into force, the justification was this is what the sector had asked for, and that it was a matter of urgency to deal with the global pandemic. Subsequently, those that the government claimed had asked for it publicly denied. And also the Minister has told Parliament that Department for Education is not aware of any local authority that is actually applying the legal changes. So the government's narrative has now moved to it being a backstop, it being a just in case change to the law, as if you can have parallel legislative frameworks working in tandem. They talk about not using the flexibilities as if the statutory instrument, when it said omit or substitute, didn't actually omit or substitute. And so just to give a few examples of the concrete changes that have been made to children's law. One is the statutory requirements around visiting, social workers visiting children in care. In law, the timescales were set. So a child who had been in foster care for more than a year and they were going to live there permanently throughout their childhood, if the child agreed, they could get a visit just twice a year. Other children, generally speaking, it would be a 6-weekly visit. The law has been changed to allow visits to be by the telephone or by a video call, which most people can draw the conclusion that that's because it's not always safe to have face-to-face contact. So that could be to the benefit of the child, the social worker, the carers. However, in addition to that, the law was changed to allow local authorities who don't make the visits, who don't make the statutory timescales, to do so as soon as is reasonably practicable. So the bottom line for children's entitlement to have even a telephone call from a social worker has been taken away. Secondly, the statutory review of children in care, which has been in place since the 1940s, has been changed to where reasonably practicable. Adoption and fostering panels, these, by the way, were part of the, they were on the list for why they wanted to have the exemption clauses back in 2016-17. So adoption and fostering panels, where before they were mandatory, these are now optional. Safeguards for children in short breaks, which particularly applies to disabled children. They, from the 23rd of April and before, kicked in when a child was in a placement for more than 17 days. That's been deleted. Even the, and Luke mentioned about the Care Quality Commission, even the statutory requirements for Ofsted to inspect children's homes and other settings has been deleted. So, and as I said earlier, all of these safeguards that were in the law, the statutory guidance for pre-24th of April is still online. It's still there. The government's justification for why children need these protections is still there. So just to reiterate, we are defending what was established child protection law. We're not making any radical, revolutionary, extreme demands. We are saying since the 1940s onwards, these safeguards have been put in place. In terms of what may be even further behind what has happened, just to draw people's attention to, in 2016-17, there was a document that the Department for Education had refused to put into the public domain, and this was a review that Lang Busen was commissioned to carry out to review how children's services could be marketised. And the project looked at adult social care, probation, as well as developments in health. And they scrutinised and made recommendations as to how similar processes could be used for children's social care. And the thing with children's social care is that there's a lot of pesky law and to get through. Local authorities have huge amounts of duties because of the vulnerability of children and because of the evolution of law and safeguards and our international human rights commitments. So the suspicion in 2016-17, and we did finally manage to get that document into the public domain, at which point the government issued a statement to say they rejected all of the recommendations that Langdison made. But the suspicion is that this is continuing that project, that deregulation helps the process of children's social care following what's happened to adult social care and probation. Again, this is in the document itself. It's not us making it up. That was a DFE funded, commissioned piece of work.
Thank you for that, Caroline. Very comprehensive response. What I would just like to say to people is that you can message Social Work Action Network on the website, and we are looking particularly for stories from practitioners about the challenges that they face, at this time, and we want it to be a forum where social workers can tell their stories, express their views, and anonymously tell us what's going on out there that might be of concern. So if you go to the website, and you can do that. And I'm going to bring Derek back in. I've got a couple of questions for Derek, or a linked question, I suppose I would say, is that, Derek, you described the human rights that as social workers we are, required to uphold, and you talked about some of the ways in that we may feel that we are compromised in our practice. So the first part of the question is, what can social workers do as practitioners to uphold human rights during the coronavirus crisis? And are there not just ways as individual practitioners that we might seek to uphold those human rights, but what about collective approach? Anything that we can be doing collectively as social workers or otherwise to highlight these campaigns? Just if you could answer that, please.
Okay, yeah, thanks, Andy. Yeah, it's a difficult one. I mean, social workers, that's what we do. We are about upholding people's human rights. It's one of our reasons for being, I suppose. Individually, I think that what social workers can do is to question and not just accept that if we're told that we've got to do something in this particular way, that we just go along with it because that's what we're told we've got to do. I think that we all have a responsibility to make sure that our practice, that as much as we can, is as good as it possibly can be. These are difficult times, so we do have conflicting, if you like, human rights, because if we are going to deprive somebody of the liberty, for example, using whatever legislation, then that's got to be done in a way that's compatible with human rights legislation. But the dilemma being that those are the places where people get detained to are probably the most dangerous places there are in the country at the moment. So I suppose that from an individual social work point of view, we need to question why we're taking that action at that time. Can that action be something that's delayed until later? Is it something that we can think about and contain in a safer way than actually introducing people into an institution? So that would be an individual response. In terms of a collective response, across most regions, for example, there are MCA regional leads such as myself. We sometimes have links into Department of Health and Social Care. So if you can go to your local MCA lead, tell them what your concerns are, that can be fed through the regional structure and eventually end up with the DHSC. It sounds a bit cumbersome, I accept that, but it is a way of getting a message up the chain of command, if you like, and hopefully in that way try and make some changes that make things better for all of us, but particularly for those people that we are working with. One of the things that I should have said earlier when I was doing my introduction and I forgot, was that particularly working with the elderly, there's been a big emphasis on the 75th anniversary VE Day and all that sort of fuss that's been made at the moment. What's terrible is that that generation, what's left of that generation, are the people that are currently in care homes and are the people that are most vulnerable and are probably the ones that are dying in bigger numbers than anybody else. So I find that particularly sad and something that, although we can't do anything about, we can be aware of, and as social workers we can try and mitigate against colluding with a system that places people in risky situations.
I'm unmuted. Okay, Derek. It tells me on the screen whether I'm muted or unmuted, so I'm now unmuted. Thank you for that, Derek. I'm just so coming back to so what I'm going to do, but before I ask Luke, there is a question that I want all of the speakers to maybe have a think about as a final kind of question, which is what should social work look like after the coronavirus? So I'll come back to that question at the end as a kind of a summating question. So for Luke, there's a very specific question, a question which is you describe the problems that exist with CAMS, services like CAMS at the moment nationally during the COVID crisis. So if they're reducing during the COVID crisis, can we expect to see anything different afterwards? And I think this is more in relation to some of the legislative changes that have been brought in, like through the Corona bill, the emergency legislation. Is, can we view this as a taste of things to come? Will we return to what we previously knew as normality, or are these types of changes likely to become the new normal?
I do have a crystal ball, actually. I do have a crystal ball on my desk and a magic wand. I don't know what the future will hold. I've been an advisor to Parliament and been involved in this for a while. And my general view is that the government hasn't got a clue about social care. It's not interested in social care. The vast majority of the people that go to conservative clubs have never used it because it's means tested. And it's not something that engages them the way the NHS does or schools do, because it's something that happens to other people. So whether things change or not is not particularly due to some sort of political campaign. Social care is only 2% of gross of the budget. It's a tiny budget, even though they angst about these things. It's a very, very small budget. If you're Secretary of State for Health, that's a big deal. But if you're Minister for Social Care, there wasn't one until fairly recently because it's such a small thing. So is CAMS going to get better? Is adult social care going to get better? Is children's social care generally going to get better? That all depends on whether social care stays in the top 1, 2, 3, 4 of the issues that arrive on MPs' doormat letterboxes. Social care has never been in the top 5 of critical priorities, and I think at the moment it is. If it is, then there are plenty of solutions out there, and CAMS, I would have thought, is the worst. If you had to say which is the worst area of social care, I would always say, I think CAMS, health and social care. I would have thought that was sort of one that we could be hopeful about. I mean, it's going to take 10 years, isn't it? It's going to take a long endeavour of investment. But I would think one could be more hopeful about that. With adult social care, you've got this sort of Naomi Klein shock doctrine, effectively, where governments do in a crisis what they wanted to do all along. So with George Bush and the Iraq War, it was privatization and giving contracts to his friends. And here we see again a huge number of contracts being given to the private sector without tendering because of this. And adult social care, the big problem with adult social care is not the money, not finding the money, because it's a very small sum. And the older people's social care costs 0.7% of the Chancellor Exchequer's budget. The problem is the only solution is to semi-nationalize it, get rid of this fragmented private sector offshoring. And that goes against the grain. So I think in those areas where you're expecting reform that will involve cutting out the private sector, it's going to be difficult. But in CAMS, that isn't really a big crucial issue. It's not a huge sum of money. I mean, it's a lot of millions, but compared to the NHS, it's not a lot. Yeah, I think you can be hopeful.
Okay, thank you, Luke. So I suppose bringing us to our final question about what social work should look like in the future. I mean, I suppose that's a bit of an introduction to that to that question. I suppose the big questions are around the fact, you know, we've had, you know, over 10 years of austerity and privatization, and some of those issues have already been identified as the reasons why, you know, the NHS and social care weren't in the shape that they could have been to respond to the crisis. I think everybody's seen lots of change, not just in terms of legislation, but certainly in terms of way we practice at the moment. We've been told, you know, that, you know, the lessons have been learned, but I know there's already concerns in local government about the financial black hole that's likely to be created by this, and will the government honour its pledges and step in to the financial challenge. But I think the question is pretty much around you know, the nature of social work that we've had. Will that change, and what should that look like? So I'll go in the order of speak. So Carolyne, if you'd like to answer that question first. Yeah,
and I just wanted to talk about the campaign that is working really hard to force the scrapping of the statutory instrument 445. And during the 2016-17 attempt by government to massively deregulate, we set up a network of organisations and individuals ready to defend children's rights, which is called Together for Children. Since that legislation, we've had 2 more actions where we've come together to defend the legislative framework, and then we've got this. And so what's been really brilliant since the 23rd of April, which is when the statutory instrument was there and public, and we could start having public debates about it, is that 50 organisations and hundreds of care experienced people and social workers and lawyers and health workers and lots of foster carers, parents, have come together to defend children's rights and to call and push for the scrapping of this instrument. And that's a fantastic base from which to work. And when we can get this out of the way, when we can reinstate children's legal protections. So when this instrument has been revoked, then the next big thing on the horizon is a care review, which the government has committed to, and that's a review of the care system, its laws, its practices, how it feels for children and for families that are in and affected by the care system. And so that's what we will work together on and rally around. And there's two really important starting points for that. One is that it absolutely has to have children and young people's, care experienced people's experiences at the heart. So that's what the care review should be about. And then secondly, it has to have a rights framework and to have the UN Convention on the Rights of the Child. So that's the next big thing for children's social care. For us, that's positive, it's hopeful, it's where we can be really creative and look to give children and young people more and to fulfill more of their entitlements rather than to defend what's been taken away.
Carolyne, thank you for that, Carolyne. That was great. Derek, I was going to bring you next in on the question around what should social work, social care look like after coronavirus?
If I'm trying to be optimistic about what social work should look like, which I'm going to try and do, I suppose one of the things that's happened during this crisis has been that there has been more emphasis placed on social care. And I think that perhaps the vast majority of the general public didn't really have any regard for social care or understand what social care did. So one of the byproducts, if you like, of the COVID-19 crisis is that social care is talked about. So it is talked about quite widely now by mainstream media outlets. So there's an opportunity there. So I suppose it's more about what I don't want to happen when the crisis ends. I still want the focus to be maintained on social care and highlighting the work the good work that all of us do, and that doesn't slip back in the agenda. I fear it will, but I hope it doesn't. So I'm optimistic insofar as I do feel as though perhaps for the first time the wider social care agenda is something that the public have become aware of, and I hope that continues and we just don't get forgotten when all this blows over. So that's what I'm hoping for.
Thank you, Derek. Yeah, over to you, Luke.
Okay, I mean, I think we've got to be positive. We've got to realise there have been some positives, as Derek has just said. I think one of the positives was the ethical framework for adult social care that was published, because obviously the Department of Health was in crisis. It didn't know what to do. And the ethical framework says, well, you should rely on professional social work, on their professional standards. And so I'm writing a book about disadvantage at the moment. And of course, my background is social care disadvantage, but it's across the piece. And the people I work with would ask for something slightly different. I mean, I assume the money is there. It's not, it's a very inefficient system. I think the money is not a problem. If you had all of that, you had all the right laws, you had all the right sort of universalism, you would still have, I think, one enormous problem. And I think what I would like to see is one of the big problems with the NHS is managerialism. This control freakery from the centre where everybody is tied down to budgets and nobody at the front line in the coalface is allowed to make any decisions. We've had a sort of complete oppression of professional standards. Professionalism goes out the window. You're just managers and you have a budget. And if you don't stay in budget, you're a rubbish manager. So I think that hand in hand with these reforms, we've got to have a real attack on control, this obsession with central control, which is incredibly expensive and inefficient, and give frontline professional social workers the right to make decisions there and then. You know, one of the biggest problems in social work is delay. I act for lots of disabled children who've got short lives. They're in hospices, and we're waiting a year to get a decision from something, whereas a social worker at the front would say, yeah, quite clearly they need it. So I'd like to see, hand in hand with some sensible legal reforms and everything else, a real recognition that managerialism is killing social care.
Thank you for that, Luke, and thank you to all the speakers, to Carolyne, to Luke, and to Derek for giving up their time this evening and creating such an interesting discussion. Just before I go, just a few announcements. For those who don't know about Swan, Social Work Action Network, it's a collective of social work practitioners, social work academics, service users, and carers who have come together for I think over 15 years now to promote a different kind of social work, a more engaged practice, bringing people together in practice and in communities to find more person-based solutions and community-based solutions to the problems that society and social work faces. You can find us online, and the previous discussions that have taken place on the webinars are on there and can be watched on there, and there's various articles on there as well. The next webinar is a joint webinar, an international one, between Swan and the International Federation of Social Workers. You'll be able to access it in the same way. It's 2 weeks from tonight at 5 o'clock UK time, and the subject is on the impact of Covid-19 on refugees, and that will be an international panel of speakers. So just want to say thank you to everybody. And just before signing off, I believe that we at the weekend we will be saying Eid Mubarak to our Muslim brothers and sisters around the world. So I'd just like to say that from all of us in advance of those celebrations, and to thank everybody for tuning in and participating in the discussion. Enjoy the rest of the evening.